You just received a 3-day notice to quit, and you don't know what to do. You don't know what the next stages are or what to expect, what's going to happen next. Well, first, understand that either your landlord or the new owner has sent you this 3-day notice to quit, saying that you have 3 days to get out of the property or they're going to start an eviction proceeding. That eviction proceeding will start by them serving the complaint on you, either by posting it and mailing it or giving it to you personally. Once that occurs, you have 5 days to respond to that complaint. If you don't respond within those 5 days, then the other side, the landlord or new owner, can seek to have a default judgment entered against you. Once a default judgment is entered against you, then they can seek a writ of possession, and ultimately the sheriff will come and lock you out. So how do you defend against this? Well, there are 3 things that the plaintiff, that landlord or new owner has to prove. They have to prove, 1, that after they gave you that 3-day notice to quit, you didn't move out. So if you move out, they can't proceed with the eviction proceeding. The second thing they have to prove is that they properly served you with that 3-day notice to quit, meaning that they either personally gave it to you or they posted and mailed it. What's more is that the proof of service that they file with the court has to reflect exactly how they served you. So if it says they gave it to you personally, but it was posted or mailed, that's a problem for them. If it was personally given to you, but they checked posting and mailing, well, that's a problem. Whatever they do in terms of how they serve it, the proof of service has to accurately reflect that. And the last thing that they have to prove is that they have a duly perfected security interest. This means that they're either the owner or they're an assigned beneficiary of the owner. So those are the 3 elements that must be proved. And any one of those elements can be attacked in your defense. Strategically and procedurally, there are some things that can be done to assist at minimum at getting more time through this eviction process. One of those techniques is a motion to quash if the service of the complaint was not proper. So if they didn't personally give it to you or they didn't post it and mail it properly, then the proper way to respond to the complaint, still within that 5-day period, is a motion to quash. Additionally, instead of filing an answer immediately, you can file a demur. That's a legal document in which you're challenging the facial complaints and whether or not it actually goes to proving the elements that are required for the eviction proceeding. So again, you can file a demur, and that will give additional time in the eviction proceeding. The court will likely overrule the demur and order you to answer. Once you've answered the complaint, the plaintiff will likely ask the court to set the case for trial. It's at that point you should file what's called a counter request for trial. And in that counter request, demand a jury. Once you've demanded that jury, make sure that you deposit your jury fees. On the day of trial, when it is set, make sure that you're not stipulating to a commissioner. If they don't have an actual judge there for you to hear your case, then you shouldn't agree for your case to go forward. Also note that once a judgment is entered against you in an eviction proceeding, it will forever become public record. So it's very pivotal that if you're going to try to resolve the problem with the landlord or the new owner, that you do it before they get a judgment, or after they get a judgment, that you agree to seal the record. This is what they call an eviction proceeding, also an unlawful detainer in California. It's important that you seek counsel as early as possible to help you with the different elements of the case that I've just described to you. And if you're a landlord and you want to get somebody out of the property who's holding over and not paying rent, then it's equally important that you seek counsel so that they can guide you through this process and you don't end up fighting someone who knows all of these various stall tactics, and it takes you much longer to achieve eviction than you would otherwise want. These are the elements of an eviction, This is the procedure you will follow if you're trying to evict someone, and the procedure you will follow if you're trying to defend an eviction. Thank you.